Hello all. Lovely to see you in inverted commas. In previous times, we would just have all had a coffee together, which would have been really nice, but we appreciate you joining us in this remote way. So my name is Ruth Stockley. I've been practicing from King's Chambers for longer than I can care to remember, so I'll not go down that point. But both myself and Piers, as he's already mentioned, are part of the Planning and Environment team at King's. And that's what we want to just talk about briefly to you. What you've probably already been appreciating, and hopefully will by the end of the day, is one of the particular strengths of King's is the diversity of areas of law we practice in, as well as the diversity of people, both members and staff. And hopefully you will find areas that we cover today that are of some interest to you. But we want to talk about planning and environment, and just picking up some of the points I was listening in on the last session. To be fair, I'd never even thought about or even heard about planning law when I was at sixth form college or even at university. It had never crossed my mind to go into that field. And it was really only when I came to King's and heard about it and saw it in practice that I decided that really was the area that I wanted to specialise in. So I don't think it's too much of a concern if you don't know precisely what you want to do, which area you want to do at this stage. Anyway, Piers and I are here hopefully to make you choose planning, but at least we don't want to totally put you off it. So very briefly, what is planning? Because I don't want to lose your interest at minute one. So I'll try and keep this really simple and brief and then get on to practical matters. But at its simplest, any form of development of any kind requires planning permission. And that's what we are in the business of doing, either trying to get planning permission for clients or to get it refused at the end of the day. And just to give you again an idea of the variety of projects we can get involved with, you'd need planning permission whether you were building a house or whether you were building an entire housing estate. If you're building a corner shop or a retail park, if you're building a pub or a new hotel complex, a wind turbine, mineral extraction, all kinds of new infrastructure, roads, railways, airports, they all require planning permission. So you can immediately see the variety of matters that we get involved with. And in terms of granting planning permission, that's granted by the local authority, the local planning authority. So here in Manchester, for example, it would be Manchester City Council. And the clients you will have in planning will be developers on many occasions, such as landowners, the house builders, retailers, those who are promoting development. You'll also very often have as clients the local planning authority, the local council, and they, on many occasions, will have refused planning permission, and they want you to ensure that that refusal is ultimately upheld. Piers will be dealing with how we get involved with that. Or you may be dealing with interested parties, local residents groups, who want to ensure that planning permission often is not given for a particular form of development in their area. So your objective is to seek to ensure planning permission is granted or that planning permission is refused, depending upon who you're acting for. So that's essentially what we do. I think a couple of other points I want to raise. In terms of planning, firstly, there is a lot of law involved with, there is law involved with planning because it's governed by statute, but it's also governed very much by policy, and policies made by local authorities and indeed by national government. And therefore you are getting involved often with politics to a degree. There's a bit of an overlap there. And you may have heard about Boris banging on about build, build, build new houses, much to our delight, of course. And you may have heard in the news about the new planning system, which is being considered. And we're obviously very interested in and awaiting what that will say. So there is that side to it, the application of policy as well as law. And the other point I think I'd like to make is that planning pre-COVID anyway, and hopefully post-COVID, does take you out and about a lot. We do work nationally at King's, so you can find yourself going all over the country, travelling around to visit sites and ultimately to attend hearings that Pierce will talk to you about. So you do have to be prepared to go out and about, to have overnight stays. It's not a 9-to-5 job, planning, by any means whatsoever, but it is extremely rewarding because of the variety of it. And then my very last point, I just want to mention that although we're called Planning and Environment Team, we do cover other areas. So just by way of example, my own particular passion, and I know Pierce is interested in it too, is highway law. Again, it sounds dry. I'd never heard of it at your level. In fact, when I came to King's, I'd never done a jot of highway law. And now I just absolutely love it. And I like the contrast between highways and planning, because highways is much more law-based. And yet there's a very good overlap because so many cases do involve planning and highways. So remember, there are other areas even in planning. There's compulsory purchase work, there's environmental work, there's village green work, there's commons work. So all kinds of variety. And it's only really when you come to practice here or wherever that you will be able to get deeply involved in those areas. So that will be an overview from planning. So I'll now pass over to Pierce, who'll deal with more what actually we would do in practice. Okay.
Thank you. If only this talk could just be on highways law.
Well, I know. Sorry.
Just to give everyone one insight, the practitioner text, the chapter on bridges starts with, well, we need to return to the Magna Carta as the starting point. It's wonderful highways law, and it's full of history. I sadly can't talk to you about it. I could talk to you about it, but I won't talk to you about it today. Just again, the same plea I made in relation to the pupillage session. There's the Q&A function. We've got 10 minutes at the end we've planned for questions, so please do ask as many questions about planning as you want. And I think, well, I think is an appropriate place to start with this is to explain why did I choose planning and what do I like about planning? And slightly picking up on what Ruth said, one of the absolutely brilliant things about planning is it's sort of the lens through which a lot of other areas are applied. So environmental law and regulation, well, that's often done in relation to housing or development. If you want to build over a green field or over a natural habitat, well, then environmental concerns are going to come in there. As I mentioned, heritage, used to be an archaeologist. If you're building on an archaeological site, or more often near a listed building, heritage aspects are going to come in. So actually planning is a multifaceted application of all these rather interesting areas. What I wanted to talk to you about today over the next sort of 9 minutes is, well, actually in practice, what will you be doing as a planning barrister? Frankly, right from the off, right from getting on your feet at the seconds, when you get into your second 6 months of pupillage onward. I've just been 2 years a tenant, so that's the experience I'm talking from. I'm not going to talk much about it, but it's worth being aware in planning. There's an awful lot of writing advices and papers. The point being that, as Ruth mentioned, this is statute heavy, this is policy heavy, this is case law heavy. So there is times when you need to go into the library, or as now the case, go online to the various texts, research, and then write advices. I'm not going to dwell on that, but it's just worth raising as one important point. That ability to have a strong papers practice is what really came to the aid of a lot of planning barristers during the pandemic, because of course when all the courts closed down and all the planning inquiries ceased, we went back and did a lot of papers. So that will always form part of your practice. But frankly, the real benefit for me, the real thing that I love about planning in practice is one of the very few areas of law which allows you to do a whole variety of advocacy. Because in my mind, there are three main types of advocacy or types of court you will be in, or I shouldn't say court actually, I should say sort of arena that you will be in. Because the first element you'll do is judicial reviews to the High Court. Now that's because Ruth was mentioning about how local authorities will grant planning permission, they'll make the decision. Once they've granted planning permission, they don't have the power to remove it. So what you need to do is you need to, if they've made an error in law, so not that you just disagree with something they've done in the sense of, well, I would have come to a different conclusion. if they've made an error in law, the only way you're going to get rid of that permission is by a judicial review to the High Court. And the advocacy in the High Court is all legal submissions. It's not really disputes of fact. It's not cross-examination. It is pure legal submissions, one barrister against the other, and the judge trying to decide who's better. And I think a lot of people find High Court work, judicial review work, as really sort of advocacy in its purest form, skeletons, case law, authorities, bundles. And that's one part of your practice there, trying to spot what's the error of law here. Have they taken into consideration something they shouldn't? I won't go too much into the sort of law of judicial review. That's one part. However, the second part, the second element of your advocacy is in what's called planning inquiries or planning appeals. So let's take the situation where a council have an approved planning permission, they've decided to refuse it. What will usually happen is then the developer will appeal it, but it doesn't go to a court. It goes to the Secretary of State for Housing, Communities and Local Government, or their appointed agents who are called the Planning Inspectorate. And what happens is then the Planning Inspectorate take the decision out of the authority's hands and they remake the decision afresh. And the way in which they do that, well, I won't go into the details of the different procedures. One of the main ways in which they do that is hold what's called a planning inquiry, which is where the inspector will usually go to a drafty village hall or local community centre and set up some desks, and an inspector will sit there as a judge-like figure. Then the various parties, the developer usually is one, the local council who refused it, usually another. Sometimes you get the locals as a Rule 6 party, they're called, as a third party. Each appoint barristers who then go and might be over a few days, might be over a few weeks, examine whether this proposal should be granted planning permission. That is done through the calling of witnesses. So what you'll almost always have is a witness who wants to talk about, well, in planning policy terms, whether this should be approved or not. But let's say also we're building 1,000 houses in the Greenbelt and it's going to impact a protected species. You might then, as the developer, need to call an ecology expert to speak about that. Say also, actually, we're near a grade 2 listed manor house, which is just on the other side of the housing development. Well, you're going to need to call a heritage expert to give evidence again. So the benefit in terms of practice of a planning inquiry is you're not just making submissions, you're also cross-examining and testing experts in their field. And one of the things I absolutely love about this job is I will, sometimes I get a few months' notice, sometimes at fairly short notice, suddenly have to become an expert in newts or an expert in air quality, and then go up against someone who's putting themselves out as a professional expert in that field and try and catch them out. And that is such an adrenaline rush and such good fun. So a planning inquiry works where you'll have opening submissions, the production of evidence through witnesses and the testing of that evidence through cross-examination, closing submissions, and then weeks, months, or even years with one inquiry I've done later, you'll get the decision about whether planning permission is granted or not. So immediately you've got that intoxicating mix, in my view, of the pure legal submissions you might be doing in the High Court for judicial review, followed by, with a planning inquiry, the cross-examination, the testing of witnesses. And I can't think of too many areas of law that give you the opportunity to do both of those things. Either it's very fact-heavy, so you're doing a lot of cross-examination, or it's very law-heavy, you're doing a lot of legal submissions. I can't think of too many where you do both. The third arena in which we appear in as planning barristers, as Matthew very rightly said, is we don't do criminal law per se. However, we do criminal law when it enters into our areas. So in planning, one of the things that happens is enforcement. If you've built something without planning permission, the local authority can take enforcement action against you. And if you don't follow the enforcement notice, a notice that literally says, tear that down, stop doing that, then you can be prosecuted in the criminal courts. And certainly I've, and I think almost all members of Chambers, have appeared in the criminal courts, either prosecuting or defending against planning crimes, also against some environmental crimes. What's the benefit of that? Well, of course, it gets you in front of magistrates, which in and of itself is quite interesting if you go to the magistrates' court as the first place. It might then, though, be appealed to the Crown Court. So then you're in front of, a wigged judge, in the sort of surroundings of the Crown Court, surrounded by sort of criminal barristers who all have no idea about planning. So you get to delve into the criminal world as well. So 10 minutes to talk about the whole range of things you do is certainly not enough with planning. But if I can summarize it as, in my view, I can't think of another area that allows you to have a papers practice, a High Court practice, a planning inquiry practice, and also a criminal practice. And it means you're doing a variety of things. No day is similar. I sadly can never really copy and paste over a skeleton or something like that. It's always different issues. And yes, that ability that Ruth asked about, don't think of planning as one homogeneous whole. You can be doing highways, CPOs. I mean, there's so many to list. I can't think of them all now. Multifaceted different areas. It gives that real opportunity. So I can't speak highly enough about planning and the variety that it has. I note we have some questions coming in. I will try and separate them out from the questions we've got about, here's a good question to start off, a very good question from Jasper. Do you think the proposed expansion of permitted development rights will reduce or increase the requirement for planning barristers?
Right, gosh, Jasper, that's quite in depth. You obviously know what you're talking about here. I think, yeah, just for those who aren't as familiar, so permitted development rights is where specific planning permission is not required for certain types of development. It's automatically granted by the statutory instrument, by the order. My view, Jasper, is that specific point, I don't think it will have a major difference. I think really we're now going into the realms of a new planning system. It's clear there's going to be a new planning system, which is going to completely change so many aspects. My view is that the work will stay. I think we will have to adapt as planning barristers, but I confess now, I've been at King's for 30 years, and for 30 years it has been constantly stated in planning, oh, there's another change, we're therefore going to have no work, all our work's going to disappear. And each time there's been changes, we have adapted, and some work's got less and some work's increased. So now in the new system and the local planning proposals, I think we're going to have more work now at local plan level rather than perhaps later on at planning inquiry stages. So I think it's just adaptation, and I think the work will remain. And to be honest, it always has. And as Piers says, there's that many areas we work in. There's always work in the planning field. Yeah.
Thank you. I've seen, yeah, I agree with that. I see I think if you were listening last time, I've spotted what's a brilliant question to end on. So I'll leave that till the end.
Okay. I'm letting you take the lead, Piers, on questions to answer.
But here's a perhaps slightly easier one or less complex one to answer, which is King's Chambers has 3 different locations, Manchester, Leeds, Birmingham. Is planning done in all 3 of those locations?
Right, yeah, that is an easy question to answer, but a very good question. Yes, it is. And in fact, we are trying to encourage planning in each of the 3 areas. It matters not where you're based, to be honest, which of the 3. Obviously, the one nearest to where you live will be appropriate, but we do full planning practice at each of the 3 locations. Yeah. So that should not affect your practice in any way.
Yes. They've picked up on the awful term I used of arenas, the 3 different arenas: High Court, planning inquiry and criminal work. And a question comes in, what would you say is the percentage split between those 3 arenas? Now Alistair, I'll say, I think that radically differs per member because there's a bit of choice about it. But Ruth, how about you answer it first, and then I'll give my answer on. Between High Court, planning inquiry and the criminal courts, where does your percentage lie?
Right. Well, I'm slightly different because, as I said, I have a particular highway practice as well. I think from pure planners' point of view, I would say they're probably doing about, this is just an average, I'd say they're doing about 2/3 planning inquiries And then 1/3, most of that remaining 1/3, this isn't going to make mathematical sense, most of the remaining 1/3 High Court, plus I would say a very small proportion of that last third would be doing criminal work in the Magistrates' Court and Crown Court by way of enforcement. I tend to do a little more court work because I do my highway law, which is one of the reasons I really enjoy it. But I would say most of the time, the pure planners, the majority of their time, they'd be in planning inquiries. But it does definitely vary barrister by barrister and the nature of their practice.
Yeah, and to add my view on that, of course, you may have seen in the news, there has been an increasing trend towards limiting the opportunities for judicial review to the High Court. So I don't think for any planning barrister, or for very few, will it form the majority of their work. Those planning appeals will form either probably, as we said, 2/3, or sometimes it'll be about 50-50. With the criminal work, again, it sort of depends where your interests lie. And you could certainly say, well, I really love this and I want to be doing more of this. I think you do more enforcement notice prosecutions towards the junior end. So I might be slightly higher up in that 1/3. But I think also it entirely depends, as I mentioned, it entirely depends on your interests. I can see, for example, John Hunter, who's going to be speaking to you in the next section. He's someone who does an awful lot of very impressive High Court work. I know because, well, I hope he won't mind me speaking for himself. You know, he really enjoys it. And so he's been, well, very recently in the Supreme Court, actually. So he's got that ability to choose to do some really interesting High Court work and above judicial review work. You can use whatever your interest is and sort of, what's the right word, mould your career to going towards more of that stuff. If you said, I absolutely hate judicial reviews, I just want to do planning appeals, that probably could be something that could be allowed to do, you could be allowed to do anyway. A next question here. I think we've got enough time for a few more, so I won't ask the final question yet, which is a very good one. Okay. Let me try and find... we've got a question here, Ruth, that says, do you have to have a prior knowledge of environmental issues or awareness to truly immerse yourself in planning?
That is a good question, and it must be on the minds of a lot of people out there. My view is the answer is definitely no. As I said, I have now full-time planning environment highway law practice, and I not only didn't know about them previously, I didn't study any of them as part of my degree, and I didn't even do any of them as part of my bar school qualifications. I'm not sure what it is these days, but yeah, I had not practiced at all in planning or highways when I came to King's Chambers. So the answer is definitely no. You'd want to have an interest in it, but it's just simply to say, when you come to King's, I have a particular interest in that area. I'd like to see some of it. And it's only by actually going then and seeing it in practice that you can really decide whether it's for you or not. So you definitely don't have to have any particular qualifications or experience in this area just to be able to practice in it. But Pierce, you're younger than me, so you may have a more up-to-date experience.
Yeah, I can't agree more with. I didn't have a particular deep, prior knowledge of environmental issues and things like that. And I would just say, of course, be aware, at least at the start of your career, you have to be on both sides. So if you're thinking, I'm going to become a planning barrister to stop all development, well, actually, you're going to be working for both gamekeeper turned poacher. You're going to be working both for developers and the people who want to stop the development. So at least in the early part of your career, you won't really have much of an ability to say, I only want to, as it were, fight the good fight. You need to act for both sides, as all barristers do in their practice areas. The final question, which I thought was a particularly good one, and we're sorry not to give you prior warning of this, because I'm sure you have so many, is this. What is your most memorable planning case?
Well, thankfully, I did see that, and I thought that was a really good question. Yeah. So, okay, mine, I think my most memorable planning case is a long time ago when I started off. I was led on a planning inquiry in relation to the Trafford Centre, and I think having the Trafford Centre approved and being involved with that inquiry for so long that now every time I drive past it, I think I had some involvement in that development. So I think probably that from pure planning, and then just very quickly to add, in terms of a case, I think my most memorable one has to be a village green case. And just to show what you can achieve in planning, that particular case did go all the way to the Supreme Court, and it has to be appearing in the Supreme Court in that village green case. That was the absolute highlight for me.
Well, I certainly can't beat that. I think the best I can do is two, one of which is quite interesting on the facts and one of which is quite interesting on the law. On the facts, last year I was involved in an enforcement notice for the council against someone who decided to create a wedding venue in, I won't mention the northern town. And the way they decided to do that was to erect a number of potentially stolen telegraph poles around to form a sort of romantic backdrop that they then would sort of photograph people against after they got married, because who doesn't want to be married in front of a backdrop of telegraph poles? That was an enforcement against them, and in the end we made them take it down. In terms of most recently, I'm in the middle of a case at the moment, brought on behalf of a local authority, where we've taken the Secretary of State to court. We went to planning appeal. We lost that planning appeal, we believe wrongly, and therefore one of the amazing abilities about planning is you actually then formally take the Secretary of State to court. The first hearing of that was against my old pupil supervisor, Sarah Reid, and another senior member of Chambers. And the exhilaration of going up against two senior members of Chambers, and at least on that preliminary hearing, we got permission to take it forward to the full hearing. Winning is an absolutely incredible experience, and one of those things you can get sort of straight away, because in judicial review, you might be up against a much, much more senior barrister. And so that was absolutely brilliant. I think, again, amazingly, we've just about kept to time, Ruth. It is now 10:15, and I think that's when we're meant to be handing over. But again, on behalf of everyone, can I thank you so much for taking the time, especially how busy you are, to come and speak to everyone today about it. Your experience of this world is obviously extensive, and I'm sure it's been really appreciated for you to give that insight.
Oh, well, lovely to see you all, and good luck to everyone, and I wish you well. Okay, and hope to see you at some point at King's. Okay, thank you.
Again, also everyone, thank you so much for your attention for me. You'll be very pleased to hear, I'm sure, that I'm now leaving after an hour. I don't know again whether Matthew's going to pass you over, but if not, I will just say, as you can already see, Sam Karim QC and John Hunter are here on the call, who I think are taking your next session. Have a very good day. It's been a pleasure to virtually meet you all. And again, like Ruth, I hope to see you at King's one day. Thank you.